really designed for that.
Right.
The airflow is terrible.
At least it's like Oregon instead of like Arizona or somewhere that's like crazy hot. But yeah.
A few used to be just occasional. Now it's usually like just several days a year. It's really a problem.
Yeah.
Good morning.
Good morning. Welcome, everyone. Good to see you all. Thanks for another day of good bargaining ahead of us. Welcome back. We are ready with Articles 8 and 15 this morning. I believe our full team is present as of right now. Susan will have to be leaving us around noon or before noon for prior commitments. But right now we're all here and looking forward to our time together.
Good morning. Most of our team is here, back and we're ready in action. We're still waiting for Diane to get back, and then Rob will be joining us again later. He had to run and do something as well, but he will be back later in the day.
All right. Thank you for that. And we are not joined by our board members today as well. All right. Well, we are, unless there's anything else, we can dive in with Article 8. Okay, buckle up. It's a long one, so.
Oh, we are aware.
Kirsty, sorry. How many extras do you need?
All right. Does everybody have one? So I'll walk us through this. A lot of what you'll see here is attempt to make a admittedly long article a little clearer. And so much of the changes that we'll see through this are an attempt to just provide some clarity and make this article a little easier to read and understand. Starting with 8A, accepting the changes for calling out the numbers. B, what you'll see there is we removed the language, the second paragraph, created a new section that we'll see later, specifically addressing position placement and review. Calling it or doing that along with step placement didn't really feel like a clear way to have those two topics presented. So we'll see that language come up a little bit later. As the new C remains the same, calling out the reporting to the designated human resource administrator. D, position placement and review. This is a new section, again, using language from that was moved from previous. However, I want to call out D1. This is in alignment with our proposal on Article 3, that salary placement of new positions or positions that have undergone a significant change will be determined by the district and shared with the union with an opportunity to respond to that placement on the salary scale. And then D2, position review, there is some clarity in language here around the purpose of position review. It is an opportunity when there's a significant change in job duties to have the position reevaluated. It's not necessarily meant to be, it's not meant to be I want to have my pay looked at for a position, but rather it's reviewed for change in the duties or skills associated with the position.
And Curtis, can I say something about that real quick? I mean, I think that the way that the old language read back in what was it, in section under step placement, the idea was, or at least the way it read to me was, if I think my current position should just get paid more, I can bring that to position review. For us, that's a bargaining issue. Like, pay rates for existing positions need to be bargained by the parties. I think what we're more familiar with is a reclassification request setup where, you know, I'm classified as this employee, but I'm really doing the duties of this other employee. So I want to bring that request forward, you know, and have that looked at. For us, that would be appropriate outside of the bargaining venue. But any, you know, this whole class of jobs should get paid more. That's a bargaining table issue for us. So that was the clarification that we were looking for there.
Thank you, Brian. In E, what you'll see is we struck the E1, the language around promotions. That's not a practice that we have as a district where people are promoted into new roles. They apply for a new role, a new position, and if they are chosen for that position, then their salary placement is covered in the existing language. But we don't just promote people or move people into new roles without them going through that process. E2, we struggled with. Our understanding of E2 is if you are, for example, a para 2 at site A and you move to site B, but still are a para 2, your salary, your step placement remains the same. And so we're not sure background-wise on E2, but if you're in the same job title and you continue in the same job title, there's no change in pay. It doesn't really feel, we didn't see a reason to maintain that. So in clarity's sake, striking that. And then the one below that, again, we feel is covered by the provisions in E1. This is saying if somebody moves down in a position, again, we follow the same format of looking at their experience and education related to the position when placing them on the step. So really removing those in an attempt to make this section just clearer and easier to understand. F, workplace closure or delayed start. So this is a significant rewrite, again, hopefully to make a admittedly confusing section a little clearer. And so what you'll see at the beginning is we broke out two sections, workplace closure and then a second of delayed start, and called that out in the title as well. And then through those, provided guidance around what we do during a closure, how compensation is affected, and similar for delayed starts. The significant change that you'll see in this is for delayed start. It's written so that employees will be paid for the delayed starts. Their pay won't be interrupted, and the expectation is that employees get to work as soon as they're safely able to do so during that 2-hour window. And so we know that individual circumstances, we all live in different areas. It may take longer in some parts of this area. It may take longer depending on where somebody lives than another person to get to work. But really, the expectation is get there as soon as you're safely able to do so for all employees during that a delayed start. And so, as a result of that as well, you'll see that we removed the reference to the $40, as the expectation really is that everybody show up when you're safely able to do so. Moving on to G, normal work hours. We struck the language around part of a flex time agreement. Flex time is defined subsequently as a ability to change time for a shortened period of time, not as a ongoing. If it's permanent, then really that's a change in your permanent working hours and not flex time. In H, we called out our current MOU agreement on overtime, how overtime will be calculated. In H1A, specifically if people are working 2 or more positions, that overtime would be paid on a straight time formula in the position that puts them over the 40 hours. H2, flex time. This was a move, calling this out as a separate section. Much of the language is just moved from a different part or previous language that has been moved within the contract. The addition there that you see bolded and underlined is the district may require an employee to flex the schedule or their schedule. And that would occur, for example, in the event of conferences or there's a operational need that's requires a shift. You know, we have parents that are on site, you know, in the evening, and we need to make sure that on those days we were able to meet the needs of our community. And so there may be times where a flex in schedule would be required. Moving on to comp time. Just really clarity would be of accrued comp time, and I think that's just a clarity change there. 4 callback provisions or compensation. I'm going to ask Charity to speak to this section as nutrition services is impacted by this one directly.
Yeah, so NS was called out in part of that, so I get to present this part. A remains the same. B, I think the addition of this does not apply to work scheduled in advance, so there's just a little more clarity about what a callback really is intended to be by definition, so that's the addition there. And then D, nutrition services staff, just clarity around this as well, because the history around this is nutrition services staff get time and a half for special events. Those are usually things that are happening in the evening or on the weekends, so like a pancake breakfast or something that NS staff might assist with. So that's why that is called out specifically, and not to confuse that with, say, a supper program that staff might be working as well. So those are intended to be kept separate. And then this portion of the flex time that has been moved is crossed out here and moved up.
Thank you, Charity. Number 5, callback charts. You'll see language added to the second section, paid holiday or closure. This also aligns to language that we've added to F on workplace closure, specifically calling out employees who are in a position that is designated for remote work. And so we want to make sure that it's clear. Right now, some of the provisions are unclear in the contract language around how it applies to people who are working remote. So this is our attempt to clarify that. And then in addition, the language there around currently there's conflicting language in the contract around working and getting a time and a half rate versus paid essentially double time when called in during an emergency closure. And so we've attempted to clear that up with the language in the second box around paid holiday or unscheduled closure. So calling out that they're paid at double time during those closures. No significant changes. J, mileage in 3, just calling out really our operational practice that mileage was reimbursed based on the mileage chart, and removing the language about it being established by the board. We follow our reimbursement chart for mileage. And the rest of the mileage is movement of existing language for clarity. K, reimbursement for personal property damage. This, again, we've heard your interest in having consistency, as much consistency as possible between employee groups. So the language that you see under K mirrors the language that we've agreed upon with BEA, specifically stating that reasonable costs up to $350 for personal property will be reimbursable with these following conditions. So that again helps ensure that you're afforded the same opportunities that other employee groups have. L, working out a classification. We've added language there to acknowledge our current operating agreement that the out-of-class pay is available when somebody's working for either an absent employee or filling in for a vacant position. In M, we also called out that pay for summer positions will either be the substitute rate or the summer rate established by the district for the positions for summer schoolwork. And I think that's our marathon run through 8. Any questions, or team, any additions?
I have a question on D. D1. Just want to clarify. Does this also include when people are placed at step zeros? Just wondering on that 14-day notification, if that will count for that notification process time for when we get those step zeros. Just in reality of knowing that we're all very busy people, and it does not often that I see the step zeros in a 14-day window.
Kirsty, I think this language is talking about a new position being set with a salary. It's not necessarily about when we hire someone where we place the individual. Is that
That's fair. That makes sense.
Yeah, okay.
I was jumping ahead, I think, a little bit.
I know 8 is a lot to dissect as well, so if there's other questions or if there's questions later, happy to address those.
Yeah, thank you. We'll just need some time, I think, to digest it. Is a big one, and it's one we're working on too, so I think all of us are trying to correlate, but I think just all of it, we were just deep diving in as well as your guys' changes. So thank you.
All right. We'll move on to Article 15 next.
Thank you.
Thanks. Thank you. Yeah. I don't realize how loud that thing is until it's off.
I don't think I heard a word Charity said, even once I turned it off, so. Chris, could you send us over the electronic copy of 8, just so when we go back in caucus, we can already have it in advance, so we can mesh the two brains together while we go talk. Thank you.
All right, I'll walk you through this one. Looks like everybody has it. Starting in that top paragraph, just spelling out of the numbers. I think we've been trying to consistently catch that throughout. We got a pronoun change at the beginning of A, definitions. Down into B1, notice of layoff, just a grammatical change. Somebody on our team in the grammar police didn't like workforce being split into 2 words, I guess. B3, some reformatting there. And then B3C is just a move. It's a move and a change. It's a move from a language that was in B5. So here we're talking about the times where a less senior employee may be retained. And so we've proposed a change there. If the less senior employee has unique skills or abilities which the district determines are a priority. The current language says are necessary for a remaining job. That seems to just be duplicative of current B3A, which says the operational needs of a position require special occupational skills. So it doesn't seem to add anything to say that again, that are necessary for the remaining job. So unique skills or abilities which the district determines are a priority could be bilingual ability. That may be not a required on that job, but maybe a district priority. And so that's just an example of one of the ways that might be applied. In B5, then you see the strikeout, because again, that's where we moved the language from, moved and modified. Going into bumping rights, C1, the request to bump, we've clarified there, it's made to the designated human resources administrator. We're looking for an accelerated process here on a request to bump. When we get into that, we have a lot of people that are hanging out, waiting to see what's going to happen to them. And if we have prolonged time periods where people are deciding to bump, then that's going to cause uncertainty. Other people will be waiting around to find out what's going to happen. So for us, yeah, people need time to consider their options, but we also need to move through this fairly quickly so that people get scared and uncertain when we're in a layoff situation, and we don't want to prolong that. In C2, we've simply incorporated the same concept into bumping that exists for the initial layoff. That is, seniority can be overridden by this notion of unique skill or ability. So that applies for the initial layoff. We feel like it makes sense that it applies for the bumping stage of things as well. And so that's the addition in C2. C4 is just pronoun changes. C6, you'll see that same concept, because we're following the process as it goes to the different layers, or the one step down the line. Here we're talking now again about a bump, so that same idea that there is that concept of unique skill or ability. We just referenced up to section B above, and that would replace for us all that struck language about the 10 working days and then a trial period of 10 days. Again, that really just sets up a protracted scenario where you may have people who are kind of wondering what's going to happen with their position, and the more we delay that out, the more uncertainty we're causing there. Number 7, we feel like is just a rewording or better descriptor than the struck language, in the sense that it's how we place anybody in a position, determined by the number of years of experience and relevant education training. That's a common thread throughout all of our proposals, through 8 and through this one. For us, it's the way we stay compliant with pay equity, is if we're always placing people, regardless of if new hire or you're a current employee, you apply for a new job, or in this case, we have a bump through a reduction in force. We feel like we always need to be placing people on the salary schedule in a manner that aligns with the law, and that is based on experience and training. So that's section C. Other than formatting, no changes in D. Other than formatting and pronoun changes, no changes in E. I'm happy to answer questions.
Can I give a scenario that might help make some of it, the bumping conversation, make a little sense? I know that there's a lot of other one-offs, just I think an easy one that might follow some of our students. Recently had a student at a middle school who needed to be transitioned into the ACE program. They proved that was the best placement. They had already had a one-on-one, but that one-on-one had not been successful at the middle school. So the team above decided that, who are we going to send someone with them? And then there was people with who had been there less amount of time or a longer amount of time with more skills, and so they were able to determine a bump on who was going to follow over a student to the ACE program. And there was a lot of conversation about, well, it should be the last employee, but the last employee was hired 2 weeks before that. They don't even know their job, let alone going with a high-flying student that needs, so that would be potentially like a bumping situation of who's getting moved to go to a new school or bumped out of the program, right? Because if no one goes, someone still has to leave because that one-on-one is not needed in the middle school building.
Yeah, I would say I'm trying to follow that.
I know as soon as I thought it would make it clear, as soon as I got into it, I was like, there's a lot of details I can't share, so this one's actually not a
Well,
very clear
and
example.
It sounds like a situation that you know way more about than I could
Well,
hope to
remember
know
that we
about.
were live streaming, and I just realized I had to rein in a lot of the conversation that normally we could have at this
No, I
table, so.
appreciate that. Yeah, I mean, I don't know if this happened in the scenario you're talking about. Obviously, in order for this article to apply, somebody has to be losing a job, right? There has to be a position that's being eliminated instead of like being transferred. Transfers would be a different scenario. So in the situation, I wasn't able to really tell if like, is somebody's
The one-on-one,
job.
say the one-on-one position is going away, because the student leaves the school.
Uh-huh.
No one goes with the student, so there's a one-on-one, but that student that needs it is gone.
And
So-
nobody new coming in is coming in
Nope,
and
no
that
new
person
students
can't be
coming in, so that
reassigned somewhere
one-on-one
else.
position is null and void at that school.
Yeah, because I think that's, Curtis, correct me if I'm wrong, that's the first thing you would do is redeploy that current employee unless there was nowhere else to redeploy them to, basically, right?
Exactly, yeah. We would look at, in this case, say, what other para two positions may be open elsewhere in the district and look at, transfer to another existing position. If we were at a point where there's a reduction and we were reducing by, say, one AAA and there are no available positions and we're truly facing a layoff situation, that's when the bumping process would come to play. And it wouldn't necessarily be the student who was previously assigned to a student who moved, but rather that's when we'd look at the bumping process and look at both the unique skill set and seniority to determine who would be the person to receive the layoff.
Mm-hmm.
That makes sense?
To give an example, in that same context, if the least senior employee who would otherwise be bumped, for example, has safety care training and they're in a position where that is really useful to the position the district determines it's a priority, then that person wouldn't be bumped and the next least senior person would be bumped.
Thanks, Gary. And of course, much of this article is driven by classification groups. That's how we kind of segment out how layoffs occur and bumping occurs as well.
All right, thank you. I think there's a lot to digest. We need to go check in, I think, as a team. Caucus, and we'll check back in with you soon about our timeline, looking at lunch and whatnot, or unless we want to decide on the lunch break now. Whatever's.
I think we're good with just checking in as we go.
Okay, yeah, we'll probably check in around 11:30 and let you know what we have with our articles.
Okay, sounds good. Thanks.
Thanks, everyone.
All right, good afternoon, everyone. Thank you for meeting with us. Hopefully you guys had a good lunch. We had some Qdoba back over there and got some work done. I think we have some questions. We're gonna start with, we have an article we want to pass, but we do have some questions from Article 15, I believe. So I'm gonna let my team go ahead and ask their questions, if that's okay.
So on Article 15, you mentioned, and I don't have that open right in front of me, but necessary skills, only necessary is crossed out. And it just seems like really vague language. And we're wondering what skills, if you could clarify. I understand there's a lot of job classifications to go through, but anybody could deem anything necessary at the drop of a hat if we don't have any logistics on it. Right? Priorities, yes. Thanks, Tom.
Thanks, Dina. Are you referring to B3C?
Yes.
That sound right? Okay. Just orienting myself to it. I see what you're saying. So the intention there is really we want to align a skill set with a position that may be a priority. So an example that we've discussed could be that, for example, a staff member at a dual language school who may bring a skill set of being able to communicate in the language offered at that dual language school may be a operational need or benefit at that particular site. And that same language ability may have a differing need or ability offering at a different site. So, you know, if you're Mandarin speaker at site A, that may be valuable given the dual language nature. And then if you are a Mandarin speaker at another site who does not offer dual language, it may not be a priority at the other location. So really being able to state that the needs of the position, the unique skills and abilities, they will have the potential to change over time and flux depending upon what the priorities of the district and the work site are.
Some questions that we have from our members that I actually got several emails that were listening to the live stream, and then some other conversations that have happened around this topic before. I think that example you used, I hear you in the idea where that can seem well intended for the students in the community to have someone have their dual language be utilized, but what I'm hearing and a lot of what my workers and our membership are hearing is the district's gonna then exploit my own personal lifestyle and home style and just decide to move them to a new school. When what if I have a routine where I'm at an early start school with my kids where I work, but now I'm gonna be forced to move somewhere else? And I know that's not exactly what the contract can say, but I think that example was ironically something perfect that I had down in my notes that I was gonna bring up later. Is this the reality of, I think this is where we really want some more fine details in this and what skills are what we're prioritizing and what are gonna be, because that can uproot and lift somebody's whole life on a change that works for the district that might be very impactful on a staff, his life. I mean, that's not really a question, but I know that a lot of our staff, I just felt the need to advocate that some of our staff are feeling that just giving the district power to pick up and claw drop people wherever they want for the district's needs without care for the staff themselves.
Thank you. I think if there was a language that you have in mind that you responded with, we'd certainly take a look at that as well. But really, again, we recognize that the unique needs today may not be the unique needs tomorrow or into the future. So we want to be able to provide a lens through which we are providing the ability both now and in the future. And so putting too tight of parameters on that, we don't want it to restrict the ability in the future. But we also hear the need for clarity, and also these moves are impactful to both the school and the site and the employees that are impacted by them. And so we hear that.
I did want to clarify one piece on this. So when you were talking about the dual language schools as an example, would the language, if for instance a dual language school with Mandarin, is Mandarin not a necessary knowledge, skill, and ability for that position?
It's not part of the requirements for a position. For example, say an OA position, we don't have office assistants that the job description requires fluency in Mandarin.
But then you could then decide that would be a priority that you would then utilize if you happen to have someone.
It's a preferred qualification, yeah, at that site, but it really isn't a required qualification for the position.
Okay. But I mean, you can see our concern where it would be something somebody would, in a literal grievance that I've lost, with far looser language, someone just kept someone because they felt they were younger and could communicate better with these folks. It wasn't a very old man that was discriminated against, but.
Yeah, that's certainly not our intention. It's really a unique skill set that is learnable like a language, but also learnable within a reasonable window of time, right? And so being able to provide fluency in a language is probably not one that many learn within, say, a short period of time. But really, again, the intention here is to be able to align unique skill sets with the operational need of the location.
But, I mean, when it came to the OA that didn't have, if you were unable to find someone to fill that position that spoke Mandarin, you would still fill it with someone who didn't speak Mandarin.
Correct. Yeah.
Okay.
Yeah, I think that the question is, as you're going into a layoff and we know somebody's being displaced and we have a school that happened to have an OA that spoke Mandarin, is the school better off or worse off if somebody bumps into that job who doesn't speak Mandarin? I think our position would be that school is not as well served as its current state of affairs where they do have an OA that happens to speak Mandarin. So.
In C7, can you explain your intent for the language of employees transferring into a different position through bumping will be placed on probationary status for 6 months?
And I'd have to look, thanks, Tom, for the question in the other part of the contract, but that is, give me a moment to pull that up. So Article 21F, existing contract language, is that an employee who is transferred into another position will be in probationary status. So it's taking existing language in the contract and also calling it out for clarity in this section as we're talking about the same subject. So 21F is a good reference point for that language. It's current practice.
So then, I have a quick question, Curtis. But I guess when I see a transfer, I usually see it more as voluntary to where bumping isn't. And so that's where I see the difference, I guess, and why one would need to be probationary, because that staff is choosing that, and to where another staff isn't, just to keep their job. So, is that?
Yeah, thank you, Stephanie. I am reading 21F. I read of 21F, and I would definitely invite a deeper reflection on this as well, but it doesn't limit it to a voluntary. It just calls out a transfer or hire into a different job classification. The probationary period would extend for that period. So right now, there isn't a distinction for voluntary versus involuntary transfers according to 21F.
All right, thank you. We're gonna go ahead and share our Article 13 leaves of absence, and we'll circle back if we have more questions afterwards.
Thank you. I do like the misplaced F there.
Do you want me to go ahead and start with the first? So yeah, at the beginning here on A1, we were just simply.
That's actually the district changes on A1.
What's that?
Those are the district changes.
Oh, okay. We're accepting those district changes you put in. Thank you for keeping me up to speed on that. Regarding the OFLA and the paid leave Oregon. Scrolling down. Yeah.
So when you had future-proofed that article under 1A by changing reference to the specific law to state or federal laws such as, our changes as you go further down perpetuate that future-proofing throughout the article. So when you get to B1, you had also struck the word immediate, which we did in B1, and made a reference to the law we already TA'd on Article 11, where we took the language from the current law defining family, referred to it here for consistency. And again, state or federal laws such as, some pronoun changes. Again, in C, laws such as. The significant change in D. And I'm sorry, I don't have my notes with me to know if that was. In Part F, we struck through the current contract language defining family and included there the current state language defining family eligible for bereavement leave. So that comes directly out of the OFLA bereavement leave state definition.
Thank you, Tammy. And I do want to call out specifically in F that we wanted to really spell it out because I think almost every one of us had a situation that we've been able to advocate or say in the last couple of years where we've had someone who experienced a loss in a building and were given misinformation around what can be considered as bereavement leave, as well as staff that have not even been offered from a supervisor the opportunity to check into bereavement leave despite multiple deaths in their family and being told that they had to use all of their personal time before they could even ask anyone for support. And then even at that case, so we really felt the need, it was important to draw it out. Just as the world changes and grows, everyone's family looks different. And I think really we felt it was important to draw out, even though we'd made references to Article 11, just because those things around leaves are going to look a lot different. And when you're grieving a family member, no one has time to read through the contract and pretend that their brain isn't foggy and that they're actually soaking in what they're reading. So we felt it was really important to kind of draw that out, make it really simple for staff going through that hardship to know that who they are supported with. And then the other one I wanted to go back to is in D. We had made some changes just on the reality of staff being sick. We've seen, I mean, we've still been seeing uptick of sickness, COVID, and RSV and whooping cough, all sorts of things that we've seen all over Oregon in the last 4 or 5 years. And the reality of we all need our insurance. We all need our insurance to survive. And we just have a lot of staff who might need to take a leave for whatever reason. And so they're using out their PTO or their sick time to account for them needing to be away for their sickness or their child's. So the impact of the first 4 days of the year, first 4 of the month, making someone not eligible to have their insurance anymore for the month due to absences has been a major hardship on a lot of employees. We do recognize that we are also trying to, we've discussed this, I feel like many times, lessen the amount of absences that we have in the district and the amount of, subs shortages stacking on top of each other. But the reality is when people are sick, and you shouldn't have to choose coming to work and infecting everyone else or taking care of a personal crisis in lieu of keeping your health insurance for the month. Having to make that choice seems really, really difficult and an unfair, just human choice. So that was part of our big change in D. Thought process change. And then one piece I forgot about that as well is we really didn't feel like it was consistent. I think we do think it's consistent with, of course, I don't have the article off the top of my head, but some changes we made, just the reality of having long-term leave the rest of the month doesn't disqualify you from, or being out sick for many days later in the month doesn't disqualify you from anything. So we feel it was important to make it, benefit and equal. And I can't think of the article. We just changed the language in, oh no, sorry guys. Oh goodness, let me do some research and I'll call it back. But the reality of, let me look. I don't want to misquote myself.
Can I make a comment on the last one we just did with,
You gotta talk louder, even with the
Sorry.
microphone, I can't hear you.
with, was it D, right? At the very end, the one that, we changed. The other concern that I would have is that if I have a month of unpaid insurance and then my insurance goes back into effect, then I may have to find a different provider or whatnot, which is kind of how things are when our plans change and stuff. And so that would be a concern of mine as well, is having to go through that process and sometimes wait months to figure that out, so.
Do you guys have any questions any other questions, or maybe need some more time to look over it? I'm not gonna find the article off the top of my brain. I think it's something in 11, but I'll have to go look and get my brain together. And that's what I was going to share.
Thank you. Yeah, we'll need some time to dissect this one a little bit, so we
Okay.
may come back with additional questions unless there's anything on the tip of somebody's tongue right now.
All right.
right.
Can we plan to meet back at 1:45 or check in by 1:45?
We're ready to respond to 11.
Oh, awesome. Sorry. Didn't mean to rush you. Didn't see the stack of yellow in front of you, Chris.
Hit it.
Thank you.
Got a little eager there and tried to take his.
So as everybody has a copy of this now, if you look at Article 11, the changes in A are not new. What you'll see changed is in Section B, your proposal of changing the language about the online platforms not always being reconciled with current sick leave balances. We have picked up your language at the end of that section. And also with striking in accordance with the provisions and referencing the statute. In C, that is no change, and I believe we're in agreement on that language now. And in D, you'll see not the same language as was in your proposal, but picking up on kind of the concept being put forward there, that it's not always necessarily a physician's note that would be the appropriate documentation. Sometimes there's other documentation, or you wouldn't have gone to a physician. But having the concept of having that be a little broader, your proposal had been to change that to interviewing an employee, and we have proposed providing a note from the physician or providing other documentation to substantiate the leave. And that would be that documentation and not just a physician certificate would be required at the end of each payroll period during the extended absence.
Thank you, Carrie. So that brings us to E, F, and G, and so you will quickly see that we're maintaining our position on the additional leave opportunities. Really, there are significant leave benefits and opportunities afforded to employees, and we see operationally that all of our roles have a direct or indirect impact on students, and when we have individuals who are out for extended periods of time, there is a significant operational need that has a direct impact on our students. And so we really want to stick with and comply with the current and existing leaves that are available to employees, but we don't see a need to add to those beyond what is already provided. In addition, we noticed the sick leave bank was set to sunset September 1st of 23. So that's really in accordance with the original intent behind that particular article. Any questions on 11?
And I apologize if you talked about this before, but what was we added the definition of the family in Article A, and I was wondering what was the spelling out what was contained in OAR 839007 quadruple zero paragraph 2 or section 2. I don't know how they do that.
Yeah, good job with the quadruple zero. I like that. Our concern with that is the OARs are subject to change, and those changes, may, if we define it here and there's a subsequent change, our definition all of a sudden becomes inaccurate. And so by referencing the OAR, we are complying with the law as it's written, and both currently and into the future, assuming that there may be changes to it, and we don't want to go through and change the contract every time there's a legislative change.
Yeah, I definitely understand the desire to have employees aware. I mean, I wonder if there's another way to do that than have it listed out in the CBA. If there's something that can come out from HR or something, just alerting to people, here are the family members that are covered. Because like Curtis was saying, I think it's just a concern with the contract getting out of step with that definition. That definition, just changed last spring about this time. And so we're just trying to keep it, fluid, I guess.
Yeah, I mean, and of course, our concern is that we want to, one, let our membership know, and two, I think this is a pretty inclusive definition that regardless of what change in the legislature or the federal law does, regarding, whether it be same-sex partners or whatever this is. We would prefer to have this locked in the collective bargaining agreement. So, because things can change, they can change to be a more inclusive definition or a more restrictive definition. So, if there's a provision in here that you guys would not like to see, that you're hoping to be removed from the federal statute, I mean, that's one thing. But if you two agree that this is a decent and inclusive, broad definition of family that we want to, show that the Beaverton School District's values and put it on paper, this would be a good place to start. And we could also add something along the lines, or any other type of relationship added to OAR.
Yeah, we can talk about those alternatives. I guess in our minds, our assumption has always been this would only change through addition, not subtraction, just because that's been how it's happened, especially at the state level. That's our presumption. So our goal is not to reference the statute so we can take advantage if things got removed from the current list, just because we don't think, that's not really where our heads are at. We don't see that happening. We'll talk about other ways to keep it.
But you could understand in this current climate why our members' heads may be at that place of rolling back rights that we thought were, constitutional.
Yeah, and I could definitely see that at the federal level. The sick leave is really going to be driven by, from my perspective, is going to be driven by Oregon state law, where I don't have the same concerns that I might have at the federal level of things getting a little.
And I share those concerns with you, but it's nice to have a contract that we can point to and show our members that this is, at least here within Oregon, within Beaverton school districts, we're protecting and we're standing up for these values against these things. So that's what.
Yeah, understood. Yeah, and just definitely understood. To be clear, again, I think I kind of already said this, our proposal is not intended to take advantage of a limitation or hope that one occurs. I think we fully stand behind all of these categories of folks to take leave for. So just feel like I want to be on the record.
Yeah, and we support that 100%.
Yeah.
Thank you.
I would also like to, I thank you, Rob, for what you shared. I think that really encompasses a lot of what we were thinking, but even when we started talking about making these changes, this was before election results were clear, before Inauguration Day, before we started seeing changes. This has been something that's been on our docket for a long time for our staff and our members. The reality is there's discrimination everywhere, and it happens in our buildings, and it happens in our schools, and it happens to our staff because we don't draw out clear definitions of who is family. Somebody of power, classified staff are the lowest people on the totem pole. They have less rights than our students. They are often talked down to and degraded. And they are also subject to the power of whatever supervisor is supervising them, or whatever internal or temporary person is supervising them for the day. If the admin are out, whatever teacher is in charge for the day, or nobody there and somebody making a judgment call. So the reality of people get put in sticky positions where they're being questioned on who family is and what that looks like. And everyone's family looks different. And we love to say all of our slogans everywhere: loud, proud, make our videos. Let's put our money where our mouth is and really show our staff that we are going to provide for them in every space. So it's not in one building, it's being taken advantage of when the other 54 are doing it right. There's still going to be one pocket of people that aren't getting treated fairly if it's not spelled out.
Yeah, and I guess I just feel compelled to say, since we're being live streamed and recorded, we in no way are presenting our proposal to make it so supervisors can individually implement a category of leave. So I guess I bristle a little bit at that. This is not so people can be discriminated against, and I don't think our language would allow that, because the OAR we reference is enforceable. We would expect if somebody was denied leave for one of those categories, we would get both a contractual grievance and a bully complaint or something like that. So I guess I don't want this to turn into we're standing for the position of being able to deny people leave for some of these reasons, because I don't think that's accurate.
All right, thank you. We'll just need to take some time and digest all of these things. So we'll check back in at 1:45. Sound good?
Sounds good. Thank you.